Back in 2013, Canada's Supreme Court made a really huge decision that put the country's sex work laws right under the microscope. And this wasn't about making sex work legal or illegal, it was about something much more fundamental. Were the country's own laws making an already legal activity dangerously unsafe? This is the story of the Bedford case. So, to really get what this case is about, we've got to start with a really basic question. Before this whole thing, was the simple act of selling sex in Canada actually a crime? And the answer might actually surprise you. It was no. The core transaction, two consenting adults exchanging sex for money, was totally legal. But that just opens up a much, much bigger question, right? Okay, so if the act itself was legal, was it safe for the people doing it? And that gets to the absolute heart of this whole story. The very laws that were supposed to be regulating the industry were actually the things making it so incredibly dangerous. And this paradox is what drove this case all the way to the Supreme Court. So you're probably wondering, how could a law actually create danger? Well, to understand that, you have to look at the people who brought this case forward. This case wasn't brought by lawyers in a boardroom. It was brought by three women who lived this reality. You had Terry Jean Bedford, a former dominatrix, Amy Leibovich, who actually moved off the streets to work indoors specifically for safety, and Valerie Scott, a longtime activist. The key thing here is they weren't just arguing legal theory. They were speaking from years of direct personal experience. So what was their argument? It was actually pretty simple. They said, look, these laws on the books, they're supposedly about preventing public nuisances. Things like keeping neighborhoods quiet. But what they were actually doing was stopping sex workers from taking even the most basic steps to protect themselves from violence. And their whole case hung on one specific part of Canada's Constitution, Section 7 of the Charter. It guarantees everyone the right to security of the person. And that sounds kind of abstract, right? But it's not just about, say, being thrown in jail unfairly. It means the government can't pass laws that put you in serious physical or psychological danger, unless there's a really, really good and fair reason for it. The applicants went after three specific laws that they said were violating this right. Let's break them down one by one. All right, first up, you had what was called the Bawdy House Law. And what this did was make it illegal to run or even just be inside any fixed indoor spot used for prostitution. So think about that. It meant that working from a stable, known apartment, the safest possible way to do it was a crime. And right here, you can see this huge disconnect. The goal of the law was supposed to be preventing a neighborhood nuisance. But what was the actual effect? It pushed workers out of those safer indoor spots and onto dark, isolated streets. It even made it illegal to use safe houses where street-days workers could take a client indoors. I mean, a measure that literally could have saved lives was banned. Okay, law number 2. This one was called living on the avails, and it basically banned anyone from living off the money that someone else made from prostitution. Now, on the surface, that sounds like a pretty reasonable law, right? It's aimed at targeting pimps. But here we go again. Look at the real-world effect. While the goal was to stop exploitative pimps, the law was written so broadly that it also criminalized hiring totally legitimate people for safety. A sex worker couldn't hire a bodyguard, couldn't hire a driver, couldn't even have a receptionist to screen clients. It forced them to work completely alone. And finally, the third law. This one made it illegal to communicate in public for the purpose of prostitution, and that applied to everyone involved, the worker and the client. And this one really shows you just how dangerous these laws were. The goal? Simple. Just get the whole business off the streets and out of public view. But the effect? It robbed street-based workers of their single most important safety tool, time. They couldn't take a minute to talk to a potential client, to screen them, to see if they were drunk or aggressive or just gave off a bad vibe. To avoid getting arrested, they had to get into a stranger's car in a matter of seconds. Okay, so the court heard all of this. They saw how dangerous these laws were in practice, and that led them to one very specific legal question. The big question was this: do these laws violate what's called the principles of fundamental justice? Basically, the court had to ask, are the law's effects on safety just totally random or arbitrary? Are they overbroad, meaning they punish way more people than they should? Or, and this is the big one, are the dangerous effects grossly disproportionate to what the law is trying to achieve? So the court looked at all the evidence, and what they found was this huge, dangerous disconnect between what the laws were supposed to do and what they actually did. And then, on December 20th, 2013, the decision came down. And it was a big one. It was unanimous. The Supreme Court of Canada declared all 3 of those laws unconstitutional. They were struck down. And the court's reasoning here was just so powerful. The Chief Justice, Beverly McLaughlin, she pointed to this idea of gross disproportionality. Essentially, the massive harm caused by these laws, the very real risk of violence and even death, was just completely out of whack with the law's pretty minor goal of, what? Preventing community disruption? As she put it, a law that stops people from getting to a safe place, well, that's a law that has lost sight of its purpose. The court also said that the living on the avails law was overbroad. It's like, imagine you're trying to catch one specific type of fish, but you use a net so massive that you end up catching dolphins, sea turtles, everything. The law was designed to catch exploitative pimps, but its net also caught legitimate bodyguards, drivers, receptionists, the very people who could make the work safer. So just to recap the court's final verdict here. The body house law, unconstitutional. The reason? Grossly disproportionate. The living on the avails law, unconstitutional because it was overbroad. And the communicating in public law, also unconstitutional, also for being grossly disproportionate. But look, striking down the old laws, that wasn't the end of it. The court knew it couldn't just leave this legal black hole. So they did something really important. They gave the Canadian Parliament a deadline. They said, you have 1 year. 1 year to go back and write a whole new set of laws. Ones that actually respect the right to security of the person. At the end of the day, the Bedford decision didn't solve everything. What it did was leave Canada's lawmakers, and really the whole country, with this incredibly tough question that people are still debating. How do you regulate an industry that society might find undesirable without making it dangerously, unacceptably unsafe for the people in it?